Alright, you guys, happy Wednesday. And this week I wanted to get into borrower defense a little more. Now, this isn't something that happens overnight. My application is not going to be submitted right now. This is something that takes time. This is something that takes thought and some practice. It's really important, from my understanding, turning an application of this magnitude in correctly the first time. So I really want to take my time and share with you guys my journey from beginning to end, what I submit, how I submit it, etc. So I wanted to start the process today by really going over in detail the basics, what they look for, and sit on it for a little bit and see what comes to mind. So let's get into it. Welcome back to the Nursing Investigation. Borrower defense to repayment is a legal ground for discharging federal direct loans. Under law, you may have a borrower defense repayment if your school engaged in certain misconduct relating to the making of a federal loan or educational services it provided which caused you harm, warranting a full discharge of your applicable federal direct loans. If the Department of Education approves your application for the borrower defense, they will discharge any remaining balance on the federal loans you took out to attend school and may also refund loan payments you already made. Borrowers must submit applications under the penalty of perjury that an application is accurate and true to the best of their knowledge. For Parent Plus borrowers, I thought this was interesting. They are also eligible for borrower defense if the conduct described above occurred to their child. Parent Plus borrowers must submit their own application and may submit an application even if their child does not. So these would be a couple reasons borrowers typically apply for a borrower's defense discharge. Most borrowers file a borrower defense application because they believe that their school misled them or lied to them about something that was central to their decision to enroll into that program. Under the borrower defense regulations, this is called misrepresentation. We're going to get into a lot of more or less legal terms here, so bear with me. For example, some borrowers have qualified for borrower defense in the past when their school made false or misleading promises, even those leading to graduation and that job placement. Or maybe they were told they would earn a certain salary with their degree, or they'd be able to transfer their credits to another school. Something that was so central to attending and that ultimate goal was ultimately affected. So when I think about my situation, I think about certain things like why I enrolled in this school, what led me to sign the contract, what I knew to be true at the time of the original and the first presented contract, what I knew about NCLEX pass rates, what I didn't know about them, what I didn't know about exit exams, what I didn't know that I was being made to take this third-party exam that's not accredited by any governing body that dictated my entry into a professional field that is regulated by the State Board of Nursing. I didn't know I could have an entire completed nursing education via, the Board of Nursing to be qualified to sit for the NCLEX, but I would be blocked by an exit exam. So I start thinking about things like that. I would have never signed up for a program if I had to put my education on the line for, in my observation, the school's benefit. So we'll get into that at a later date, but right now I'm really thinking about all the things that I feel like, in my observation and understanding, was led to believe that ultimately got me here to a completed nursing education, but not unable to enter the professional field of nursing based on these technicalities that shouldn't even exist, in my opinion. So before I turn in my application, I wanted to know certain things. What do they look for? What is the foundation they look for in a good borrower defense application? Substantial misrepresentation, substantial omission of fact, breach of contract, aggressive and deceptive recruitment, judgment, or a prior secretarial action. Now, I'm sure most of you don't know what any of this means, and I've just learned what these things mean over the past few years, and I'm still a little rusty. So let's go over the most important ones. So, from my understanding, substantial misrepresentation is important, I believe, for me to dive into in my application and explain, because I think it would describe possibly, potentially, maybe a representative of the school's statements or representation that may be seen as false or misleading. How that statement and misrepresentation concerned me, that the school's educational program, the financial charges, or the employability at the end, or the graduation itself was ultimately affected by these concerns, and why that harm I feel like I may have suffered justifies a full loan discharge. And I want to be clear, even if I were to get a loan discharge, this does not make anything right. Like, we do not break even here. I still 100% feel like I earned my degree and my eligibility to sit for NCLEX, and I will keep fighting for that. This is something that shouldn't happen on the financial end, so this is two separate things. Substantial omission. I feel like my application could include something like the following. Possibly information that could have been concealed from me, suppressed, or omitted. Because even if somebody doesn't come out and flat out lie, there is such a thing called lying by omission. How that evidence itself, what was ultimately concealed, suppressed, or omitted, relates to the central of my whole lawsuit. The entity providing instruction or services at my school. I think about those third-party companies that they could be contracted with, that had no authority, accreditation, that wasn't a governing body, that affected my entry into licensure. The availability of openings in that desired program, what that looked like, how I entered it. You know, whether something in the program prevented me from getting into my professional field, although I completed everything legally required to be considered qualified, you know. Why all of that harm ultimately justifies, from my opinion, a justified loan discharge. Breach of contract. I've included this in my lawsuit. This is the contract between the school and I. I think of questions like, did the school fail to keep its promises under the original contract, under what the representative, the admissions representative walked me through, and what I was under the impression of that I was getting myself into? Did anything conflict there? Did the original contract conflict with the syllabus? What was I told? What was I wasn't? What was it made to look like to be? When did I find out that central information? Was it too late by the time I found out and I couldn't back out anymore? I also think about how those contractual promises relate to the reason that I took out those loans and those educational services. Again, how all of that harm justifies a full loan discharge. I think about aggressive and deceptive recruitment. For example, in past, students have filed borrower defense applications when there was aggressive tactics or deceptive recruitment and tactics schools used to get you to enroll, to get you to sign that contract. How that conduct related to your decision. Did you feel pressured? What did they say? How did they say it? How many times did they reach out to you? How many times did you have to go into the school for 1, 2, 3, and so on, interviews? Again, this relates back to the suffered injuries of that financial burden that would justify the full loan discharge. A judgment. There have been students in the past who have also filed suit and were pending judgments or have already received one in some kind of way that ties into the borrower defense application. A judgment against your school that was issued by a court or administrative tribunal. I've even seen other borrower defense applications where students have turned in somebody else's lawsuit that related to the same conduct and the same issue they were describing to show this is a pattern, to show that more students were affected. So even if I didn't have a lawsuit, that doesn't mean I couldn't submit somebody going through a similar situation that did have a lawsuit for the same thing and won, or they're still going through it. Any evidence pertaining to what you feel like, what I feel like actually happened helps paint that picture. So it's really important to understand that they're looking for as much detail as possible. Ultimately, it would be best from my understanding to show who won the case. But they will also accept court hearings that are still pending and what happened thus far in those hearings. Again, this relates back to the harm that you suffered and why it justifies a full loan discharge. This one's a little more tricky. The prior secretarial action. The U.S. Secretary of Education sanction against your school, there must be some sort of denial, this means, of your school's application for recertification or revocation, I believe the word is, of your school's provisional program, like their accrediting program or the agreement that was taken back. You know, how the secretary's action relates to those misrepresentations. So if there's ever been a judgment against your school in the past, if they've ever had their funding, taken away, if there's ever been an investigation, those are things that if I found, I would bring up in my application. Again, showing how that harm I suffered justifies a full loan discharge. So ultimately, I think these are key pillars for myself that I'm going to look at and dive into and see what they really mean, because from my understanding, when I fill out this application, you get one shot. And everything needs to be included. Nothing can be left unsaid, and it needs to be presented in a way the legal system understands it. understands it. It's not like you're sitting on the phone here and I'm talking to my girlfriend, hey, this happened, I'm so upset. This needs to be put in the right way. It can be translated into the court of law. That's why I think it's important that I take my time and truly make sure all my T's are crossed and all my I's are dotted. Did I say that backwards? So now that you know the basics of the pillars that I'll be looking at to go through during my application, I also wanted to read you an important message that I found helpful that the Department of Education wants to be clear on before I submit my application. So under the 2023 regulation, the borrower defense application must be materially complete. Again, materially complete. So this could make all of the difference. So for example, when I went into court pro se at the beginning, no idea about law really, no idea what I'm doing. My opening statement and what I said to the judge at first in the four corners could have been so much better. Thankfully, I did have a few key points in there. I had the harm in there. I had a legal claim in there. But it's so important in that sense. It's materially complete. That wrongdoing needs to be in there. What you lost and suffered because of this injury, and in this case financially, it has to be complete. It has to show the full picture. It has to be translated in a way the law can understand it. So I want to share with you what materially completes. This also includes the pillars that we just talked about previously, but for your application to be considered materially complete and be able to be reviewed, it needs to include those pillars from what I understand, and also a description of one or more acts or omissions by your school. So for me, I feel like I would have to explain, what my school did or failed to do that warrants a borrower defense discharge, like what that misconduct in my observation looks like. I'll also think about how the school or a school representative committed the act or omission. So maybe I'll include what the school committed as that misconduct, what was said to me, what wasn't said to me. Maybe I'll think about how I experienced that misconduct that I alleged, take them through the journey with me, what it looked like, put them in my shoes. How this act or omission impacted my decision to attend that school, to continue attending that school, or take out those loans, which that you are asserting a defense to repayment for. So I think I would explain how that alleged misconduct affected my decision to enroll and continue my time there at the school. Again, what it looks like to be me, how this all happened from the beginning. Or maybe the detriment that I suffered as a result of the school's act or omission. Paying in full for a nursing education being done as far as the board's concerned, but due to an administrative duty, a technicality, I don't have that graduation date on my transcript and that conferred degree, that and that verification to get my ATT to sit for my NCLEX, that completely blocked me from getting into the nursing field, because if I can't take my NCLEX, what good is the whole degree, especially after I've done everything I was supposed to do. What does that look like for somebody like me? Under the 2023 regulation of the borrower defense, having a material complete claim is not necessarily enough for your application to be approved. This is why I say I'm going to take my time. Although everything is important together. It's about quality of the application and not quantity of what I have there. Even if you list every pillar and you have everything they ask of you, it still may not be enough if you don't give them the full picture. So I think it's crucial that I provide as much detail as possible when I fill out this application. So I want to take my time and thoroughly read through this. So I continued. It looks like applications are only approved after reviewing claims, the evidence, and the school's claims and evidence. They can determine whose claims are more likely to be true than not true. So not only will you submit your side of the story, talking about myself, but when I submit this, the school will have an opportunity to respond. And for me, in my place here, it's already so, bless you, disproportionate that I know I'm up against such a bigger entity that I have to take more time on this, because from what I know, any chain company or large entity like that have way more resources than I ever will. Maybe not ever, but as of now, that's just the facts. So when you know who you're going up against, I think I just want to make sure I'm taking my time. So these are some questions from my understanding the Department of Education, the government, they will ask. What exactly did the school say or represent to you, conceal, or suppress from you? Who or what provided me with this information or concealed this information? Include as much detail about these people that you have. When, where this happened, where that conduct occurred, what day, what time, the approximate, even if you don't remember specifically, as much detail as possible. The time of the year itself, whether it was during an on-campus tour, in an interview, on a phone call, in an email, in a meeting. How was the information communicated to me? Advertisements even, marketing material. How was the information deceptive or misleading? How did I determine that the information was as such? Why was the information provided to me or concealed from me when I enrolled in a way that influenced my decision? How did this conduct overall harm me that would warrant a federal direct defense loan discharge? So these are questions that I will be asking myself over and over again. And I also will be gathering documents. I think it's important to provide as much documentation as possible. Documents that support my claims that potentially, if I was lied to, if I was misled, any communications that would support this. Does the first contract match the second? Does it match the student handbook? Does it match the marketing materials? Does it match the emails? Does it match what happened in the admissions office? Does it match now my court documents? What do those say? What does mine say? What does the school say? Takes a lot of investigative work. What did their marketing materials say? What have other students experienced? Any documents from the school themselves, your start date, what that outline looked like, what were your projected courses, clock hours, what was the hours program look like, what does my transcript look like in comparison to another student? And one thing I wanted to get back to and be clear on, when we talk about including lawsuits from maybe, for example, the government suing the school or another student or whatever the case may be, for example, yes, a judgment is always a great thing to have when you're trying to show your perspective of what you think happened. But even if no judgment exists yet, the government understands that things like this can take time. So even if I can include as much documentation as possible to prevent waiting until there is a judgment, it can still be very much helpful to paint that picture. So they will accept enough information about the case so they can locate it, the case number, the parties involved, etc., to help gather factual information and a timeline about what you're trying to tell them. They need to be able to verify what you're saying is accurate and more likely to be true than not true. And then a lot of people ask, oh, if I've paid off my loans before I submitted my application, or like now with the SAVE plan ending, what if I already started paying? Because even when you submit the borrower defense application, you're still on the hook for that interest that's going to continue to grow until that application is approved, if it is approved. So will I still be eligible for borrower's defense? So to be eligible, it cannot be completely paid off. From my understanding, there has to be a balance. You have to have one or more outstanding federal student loans that relate to this problem of why you're seeking the relief. The outstanding loans have to be associated with the school that is the subject of the borrower defense application. If the claim is approved, ultimately you will receive a refund for what has been paid, and what hasn't will be wiped away. The borrower defense application contains sections and prompts to answer literally all your questions you're asking me. It provides all the information you need to try to submit the strongest possible application from what I've seen. So that's why I wanted to include the borrower defense website here, because there's a lot of useful information. And again, I don't want to overwhelm myself. So I'm taking it one step at a time. This first step was just kind of reviewing, what does this look like for me? What are they requiring? Is this something, just anybody like me, Joe Schmo off the street, can do? Now, you can submit, from my understanding, I can submit my application via paper or electronically. Nowadays, after going through this whole legal battle, I prefer electronically so I can save everything in multiple ways and I never lose it. I always have, for example, an insurance policy somewhere, unlike, a piece of paper that can be lost in the wind. If I can save it in multiple places electronically, I know, worst case scenario, if something weird happens, that it's going to be somewhere else and I can find it. So after I apply for a borrower defense discharge, it looks like they will review the application. If it's missing basic information like, my signature, my school's name, they'll email me asking for that information. Again, the school will then after have the opportunity to respond to those claims and provide its own evidence. Now, once the Department of Ed makes a decision on the case, then I will be notified. If my claim is approved, I will receive a discharge related to those claims and a refund of payments made for those loans. This means I would no longer have to make payments or be responsible for them. It's just completely wiped away. And again, I just want to be clear, this is two separate things. If this does get approved, if this does happen, that doesn't say, oh, I'm not owed the ability to sit for my NCLEX. I'm not owed that conferred degree, that conferral date on my transcript. These are two separate things. Right now, we're talking about the harm that caused me that should have never happened financially, and what it's going to cost me moving forward now that the SAVE plan is over. Something I shouldn't even have ever experienced. That doesn't make the action right. These are two separate things. So even if this does happen, that does not say this is refunding me for that material thing I lost. Like, that's irreplaceable. Money can't fix that. Giving me a refund for that doesn't fix that thing, but it's saying, hey, yeah, this shouldn't have happened. And yeah, so I just want to be clear on that. This doesn't mean I'm going to stop fighting for that. It doesn't mean I'm not owed that anymore. Even if I did get a refund, that doesn't mean you take what I've already earned back, if that makes sense. That's what I feel like. So under that 2023 regulation, when it comes to borrower defense applications, they have 3 years to make a decision on the application after receiving it and determining that it's material complete. And the average person may look at that and be like, oh, that's a long time coming. But this is what I think about. The time is going to pass anyway. And so what if it takes 3 years when you're looking at somebody like me who can't even get into their profession, who's going to be stuck with these loans forever anyway? So it's worth a shot, right? And then on top of that, I think about all the other students affected. You know, what does that look like with this interest now accruing times hundreds, if not thousands, possibly, of affected students? How much that debt would look like in total? And if the Department of Education brought that figure to the school, what would that look like? That's a lot of money, like extreme amounts of money that I should have been able to pay off by now entering my profession. It should have been done. Like, I shouldn't even be in this position to have to choose a new repayment plan, all this interest, etc. That's what I mean. So during this time, I'm still legally on the hook for all of these loans, and that interest that's growing isn't going to stop. But I have hope that there's another way out. So again, going back to, what if there's hundreds, if not thousands, of other students affected by this whole exit exam policy? During that 3-year period, it will be paused if my application becomes part of a group application process at any time. A group application is a group of students putting in similar complaints. And through my research, if a large number of students that have experienced the same thing file separate claims against the same school for the exact same situation, it dramatically increases everyone's chances of winning. That's it for this week. I kind of just wanted to open the door and see what the borrower defense application required, if it was something that could be done, how easy is it, how much time and effort is this going to take, is it going to be an overnight thing? Definitely not, but I feel like this gave me some solace in knowing this definitely can be done for the average person like myself. So I will keep you guys posted on my journey and how I start this application process. Again, this video isn't going to be out next week. It's just going to pop up over time, the steps that I'm on. Also take into consideration that I'm in active litigation, so I don't share anything in the moment. I'm always light years ahead, so that may delay in from what's happening in real time to when I tell it to you. So just bear with me. I won't forget to share my journey as I go. Some questions and comments for the week. Alfonso Eliasor says, this is a huge help. I will be waiting for your walkthrough to start mine too. I'm glad that I can share my journey with you. Britt says, mine is in. Nicole Wright says, this happened to me twice. I can still log into my ATI and the ATI exit exam that I took. I have an 89.9% chance of passing my NCLEX on the first try, and they would not give me my ATT. What do I do? Well, I can't tell you what to do, but I've definitely shared my journey here and what I've done. And I think this is a great point that she brings up, having almost a 90% probability of passing the NCLEX the first time, and that's why, more or less, we can't get our ATT to sit for NCLEX. Like, make it make sense. People think, oh, you failed it. This means you weren't competent enough to be a nurse. Literally, that's not what any of this means. Gigi says, can you please let me know how to file a claim? I was dismissed from the school and unable to go to the next semester due to the ATI test, even though I wasn't a student? I don't know. Unable to go to the next semester due to the ATI test. It looks like she went to write more, but it got cut off. This is such a shame. Angie says, thank you for this. Can you let us know what we need to do now, please? Angie, I will definitely be walking you through my journey and what I did. Life Beyond Expulsion says, I'm in the process of applying. Have you applied? Asked and answered today. I am doing my research and taking my time, but we'll be sharing my journey. Alright guys, so I hope you enjoy the rest of your week. And stay true, stay on the side of truth, stand up for yourself, stand up for what is right. And until next time, bye guys.